Stage, we will go live on a video link with a witness that will be testifying from the United States. Thereafter, I believe that Mr. Van Reyns, a family member, will testify, and thereafter we'll deal with the arguments. Hopefully between today and tomorrow we can complete that process so that we can finalize the matter on Thursday. That's the current planning. Thank you, Ms. Sonnepoel.
My Lord, as indicated in chambers, I think we will start off with the probation officer's reports that have been requested by the court.
They are witnesses that are actually court witnesses, but as is customary, I'm going to ask the prosecutor to lead the witnesses. Do you know who the officials are that are here?
Mr. Peterson, my Lord, Errol Peterson.
He will be presenting.
My Lord, if I understand the position correctly, he actually drafted all three the reports,
Yeah.
Mr. Peterson. So I'm of the view that there's only one witness. I have not seen him.
I believe that he is here. Hey.
Mr. Peterson, Errol Peterson.
I was told this morning that the social workers arrived and
My Lord, I'm told that apparently there was some correction to be done and he left. Can I throw over the whole apple cart and suggest that we start with Dr. van der Walt? He is available. He has indicated that he is online. Left. The social worker has left, my Lord. I believe that he will be returning. If it's possible, can we perhaps...
It's unacceptable. I told counsel in chambers this morning what happened on Saturday past. The requests for the reports were sent. We had an undertaking that the reports would have been available 4 days prior to today. That meant it would have been available on Friday the 23rd. When it didn't arrive, it was my registrar followed it up via email, only to be told on Saturday afternoon that they want a postponement. The Department of Social Development. I intervened. And after some threatening emails by my registrar, all hands came on deck and the reports were available yesterday. But this is not the way it should be done, and I take it the supervisors and the heads of that department who were all copied in on the email of Saturday afternoon and the operations over the last weekend take note that this is the way officials act and deal with the courts. And action must be taken. So, are we ready to link in with Dr. van der Walt? Can I just, you've already joined me. So how are we going to do it? Are you going to project it on the big screen?
I am going to try to do that, my lord.
Well, if I can't see anybody else that's on the platform, I see myself and Avat is in, it still says there must be a request to join. There he joins.
My lord, I did communicate to him to say that we would probably get to him by 11, so I'm glad to hear that he's still there and hasn't left, that he's still online.
I can see
Also
him on
trying
my
to-
screen.
Thank you, my lord.
Good morning, my lord.
Good morning, Mr. Van Avat, or Dr. Van Avat, I apologize. Are we going to project it onto the bigger screen, Ms. Swanepoel?
We're going to try that, my lord.
Just bear with us for a moment, Dr. Van Avat.
Sure, my lord.
What time do you have it where you are? I see you're based in DC,
That's correct, my lord.
so is it 20 to 7 in the morning? I mean, 20 to 4 in the morning.
That's correct. 24.
It's hanging. It's hanging.
All right.
I'm sorry, my lord. This is Murphy's Law. Now the PC is just hanging. It's just doing nothing. I'm trying my best. Please bear with me. Can you find your teams?
Well, there's maybe another way to do it. Oh, there we go. Just want to get Ms. Swanepoel to join the team. Are you going to be long, Ms. Swanepoel? I'm admitting you.
Thank you, my lord.
All right, I can see it on the screen. We've already started the recording. May I have your full names for the record, please?
Dr. Van Avat, can you hear us?
Can you hear us?
There's an echo.
can hear you and Judge Erasmus perfectly well.
Can you just repeat your full names for the record, please?
Sure, my lord. It's Marcel van der Walt.
Any objection in taking the oath?
No, my lord.
You will then swear the evidence you will give will be the truth, the whole truth, and nothing but the truth. Just say so help me God.
Yes, my lord.
Thank you. The witness is sworn in. I'm going to mute my own microphone on the laptop. Thank you.
As the court pleases, my lord. Thank you. Dr. van der Walt, for record purposes, can you please state your qualifications as well as your experience?
Sure. I have PhD in justice. The main focus of that study was the investigation of trafficking persons for the purpose of sexual exploitation. And I also have a master's degree in forensic investigation, which revolved around the issue of serial rape in South Africa. I've also been a member for 10 years, and that followed 10 years in academia, where my research focused around the violence against women and children, missing persons, missing children, and sex trafficking, and obviously the interweaving of these phenomena with organized crime, and that's the focus of the.
Just one moment. What is the problem? Do we maybe have a microphone that I can put it at my speaker to amplify? Because the one that you use there is too soft, apparently people can't hear.
I know that on the previous versions, we had
We also don't want to create unnecessary feedback. Let's try again. All right. Okay, Ms. Wanapol, you may proceed. Let's see.
Dr. van der Walt, we apologize.
That's better. I've turned down the sound on my laptop. Thank you.
That we got it, and that it was recorded. But
I am recording on the Teams platform
Thank you, my lord.
that's integrated with our own internal recording for the record.
Thank you, my lord. If I
Because
may,
it's done on the judiciary platform.
thank you,
Thank
my
you.
lord. Seeing that you are an expert witness, it is so. Can you confirm that you have also provided this court with a report and also a comprehensive curriculum vitae?
That's correct, my lord.
Now, Doctor, in relation to your expertise in the field of trafficking in persons, just give us an idea, how long have you, in time-wise, how long have you been involved with trafficking in persons, and specifically the investigation as well as the research and in the academia thereof?
Sure. So it's been a period of 23 years from several different perspectives. It started off in frontline law enforcement, investigating with the Family Violence, Child Protection and Sexual Offences Unit, that, as well as cohorts. That was for a period of 10 years, again, where my work focused on investigations into these phenomena across South Africa, really. And that was followed with a 10-year career in academia. That's where I completed my tertiary qualifications in research. Again, the focus on organized crime, sex trafficking, violence against women and children. And in tandem with that was my work with the National Freedom Network, where I was the case manager for a period of at least 10 years, but over a period of 12 years, received, managed, and or investigated probably in the region of about 900 reports and related reports to trafficking in persons. And then after leaving academia and the National Freedom Network, my work currently in the United States really focuses on the web of sexual exploitation. It's this kind of an augmentation of what I've done previously in South Africa.
And your current position is?
I will refer to two. I do hold a research fellowship at the University of the Free State Center for Human Rights in Bloemfontein. I am also the president of the National Center on Sexual Exploitation here in Washington, D.C. And I might add, I'm also just a council member, active council member of the South African Professional Society Against the Abuse of Children.
Now, as I indicated, you were specifically requested to, in this instance, provide this court with a report, an expert report on trafficking in persons, and more specifically, to assist this honourable court in coming to an appropriate sentence on the trafficking in persons.
Morning, my lord. We don't hear a thing. We don't hear a thing.
It's just too high. Thank you, my lord. I think that would be better. I think it was just too high. My apologies. I'm just going to repeat that. Doctor, you were requested to provide an expert report for this court for the purposes of coming to a just and appropriate sentence in this matter. Can you confirm that? Right. And you did, in fact, draft such a report. The report itself consists of 28 pages, which includes the bibliography at the end. end. Then there are Annexure A and Annexure B, there too. Annexure B is, or Annexure A is 2 pages, Annexure B is 5 pages. My apologies, you are indeed correct. Annexure C is from page 4 to 5. My apologies. So Annexure B is only from 1 to 3. Okay. Now,
So it will be Exhibit RR.
as the court pleases, my lord. Now, I want to beforehand just thank you first, Doctor, and that is for the comprehensive report that you had drafted in a very short time span, because you really did not have lots of time to do this. So thank you very much. We are indebted and we really appreciate your work done.
I'm honored. It's really a privilege, so I'm honored. Thank you, my lord.
Having said that, I have gone through this report a number of times, and there's nothing that I think can actually be excluded to say it's not appropriate or not relevant to deal with it. I will therefore, with the leave of the court, request you to deal with your report, to go through your report as you had drafted it for us. I think that would flow chronologically. I'm not going to ask you to go further than your report itself, because all of this will be an exhibit before court.
Yeah.
So I'm going to ask you to just go up to page 22.
He can start from, because he's already given us the his own background,
Yes.
but for purposes of completeness, if he can start from item 2,
Yes.
which is to be found on page 3 thereof, the information sources, and then we go on to the global and local overview. And then
Thank
we-
you, Mama.
And then we can carry through.
Thank you, Mama.
I've confirmed this morning with council that everybody received the report beforehand. So, Doctor, you may proceed and you can read it into the record. And if you want to pause and comment on a particular aspect, feel free to do so.
Please. Thank you, my lord. Thank you, Doctor.
Thank you, my lord. Just to confirm, my lord, that I understood that correctly, I will start reading with the report, and I will pause at relevant places, and I will start at information source on page 3. Is that correct?
That's so.
Indeed.
Thank you.
Right. Okay. I will proceed at information sources on page 3. Just a question, shall I read the opening paragraph or just the sources consulted, my lord?
Read the opening paragraph, I think.
Sure. Okay. I will proceed accordingly. This report is based on 23 years of professional experience in addressing trafficking in persons, organized crime, and the web of sexual exploitation, and encompasses roles in law enforcement, criminal investigation, expert court testimony, academia, and both local and international research. My background includes extensive experience in specialized units such as the South African Police Services, Direct 20 February 2004 as a country that ratified the protocol. South Africa is bound to develop laws to protect the victims of trafficking and to prosecute offenders in a manner appropriate to the seriousness of the offence. On any given day in 2021, an estimated 50 million people were living in modern-day slavery, including 28 million in forced labor and 22 million in forced marriage. And a large ideological framings around and this call for fully decriminalizing the sex trade. It's currently on the agenda, and there is this call to make legal the rights of men to purchase sexual access to women and children. A very vocal debate which is ongoing, and again, I think it's really diluted our understanding of human trafficking over an extended period of time. I'll continue reading. Studies attempting to quantify the phenomenon of trafficking in persons in South Africa have also been critiqued for truncating the scope of the definition of trafficking and even excluding cases involving the use of force. These South African studies were criticized for correctly coding cases as not being trafficking and thus undercounting the prevalence of trafficking for the purpose of sexual exploitation. The collection of reliable data in South Africa is clearly problematic, whilst an urgent need exists for a database that reflects national level and aggregated data. Trafficking in persons in South Africa has also been referred to as an elusive statistical nightmare and a situation that may in fact be far more chronic than anticipated. Several South African studies dating back to the 1990s provide real-world insights into the embedded realities of trafficking in persons in South Africa. In one of the earliest studies in 1996, researchers documented the reality of girls as young as 8 years old being exploited by brothel owners, whilst others aged 11 and 12 were held and exploited in dilapidated apartment blocks. Overwhelmingly slanting towards sex trafficking and sexual exploitation in South Africa's sex trade, their findings lend support to the conclusion reached by Professor Philip Frankel that it would be a surprise if South Africa did not have a trafficking problem. And, he was the author of the seminal book, Long Walk to Nowhere. Okay. The study entitled Research into the Nature and Scope of Trafficking in Persons in South Africa, Prevalence Insights from the Criminal Justice System and Relevant Reporting Mechanisms was released in January 2023 and provided a comprehensive examination of trafficking in persons in South Africa. That study, if I may just pause, was a subset of a larger national study. And I was the author of a specific one, and why I think it's really relevant, and my knowledge is for the first time we tapped into all the different buckets of knowledge and insights and statistics. So I'll just go through some of those. This report provided a comprehensive examination of trafficking in persons in South Africa, drawing on both qualitative and quantitative analysis of ongoing and successful prosecutions, statistics from stats, statistics and qualitative insights from NGOs, and a quantitative analysis of media reports. The empirical foundation of the research included data from several key sources, reports from 3 national trafficking persons NGOs involved in provincial and national trafficking persons task teams, as well as 1 national NGO focused on missing persons. It also included available statistics from SATS covering the period between 2007 and 2021. It also included ongoing trafficking prosecutions in South African courts during 2021, and also trafficking persons cases successfully prosecuted in South African courts between 2007 and 2022. Together, this mosaic of evidence highlights consistent and coherent themes identified in prior trafficking research, ranging from reports and academic studies to survivor autobiographies and evidence-based media reports. I will just very briefly, if I may pause, just mention what the main themes in that study was. The first one was that the fact that the fact as Dr. Kruger found is really a sharp rap prosecution tool, so we've got a brilliant act. The challenge is now is to fully implement it. The second finding was really that there is a scope, a spectrum of additionally, between 2018 and 2021, SAPS reported 781 South African children as victims of child trafficking. This figure was confirmed by the Minister of Police, Becky Cele, in response to a parliamentary question. My Lord, this is also another challenge we have. This is disconnected pieces of buckets of numbers. A lot of this data is really managed in Excel spreadsheets, and often do not speak to the different no way that research are ever able to keep up with the dynamic field of human trafficking. I just think that's just an important point to convey. I'll just continue reading. Countless cases of trafficking persons remain unidentified or undocumented, indicating its pervasive nature. Trafficking in persons is deeply embedded in daily life, fueled by societal demand for cheap and exploitative services, and it's exacerbated by South Africa's interconnected sex and drug trade. Structural inequalities, an abundance of vulnerable populations at risk of exploitation, and widespread social indifference to the suffering create conditions where trafficking in persons thrives with little resistance. And may I just add the impunity in many ways as well. Many trafficking persons-related criminal operations are fluid, adaptable, and highly sophisticated. These crimes rarely exist in isolation and are often accompanied by other offences such as fraud, drug trafficking, money laundering, and corruption. Additionally, activities like firearms dealing, stolen goods, retail crime, and cybercrime are frequently interconnected within the broader criminal landscape. I'll just pause here and say this is only a small fraction of the things we've seen in South Africa. I have personally reported the issue, the and increased vulnerability to manipulation. This is exponentially compounded in the case of familial trafficking, where the very individuals trusted with the child's care become the facilitators and or perpetrators of exploitation. Such betrayal not only strips the child of their primary source of protection, but also complicates detection and intervention. Familial trafficking exploits the trust inherent in caregiving relations. It erodes the child's sense of safety and identity, and it often silences them through fear I think, the ghost children is an apt reference. And the commentator mentioned that these are the type of children whose births are not celebrated, and therefore whose deaths are not mourned. And I thought that was a poignant, visceral statement, and really an indictment on humanity in terms of, the surmise of some of these kids. I'll continue reading. One of several examples of South Africa's ghost children is highlighted in the case that the author personally managed. My Lord, I'm referring to myself here. It was a case received through the National Freedom Network, and I would often receive these cases. I earlier cited the region of about 900 plus human trafficking cases that I received, managed, or investigated after dealing with the police. So this kind of a part-time ad hoc function that I kind of held and that I did. And often you would receive these calls from people where they were not able to report cases to the police. And then we, as a National Freedom Network, we would jump in and we would pretty much complete an entire case report, a case document, and we would then hand that over to the police. But I remember in this one instance, this was an elderly lady from Anchorage, Victoria, and she reported a case concerning a 20-year-old stepdaughter who went missing after traveling to Johannesburg for a job opportunity. After receiving no assistance from SAPS, she made contact with me and I obtained a statement and the case was officially registered. The stepmother explained that her stepdaughter, and I'm using a pseudonym here, Tengi, left home on 6 December 2019 to accept an employment offer. When Tengi failed to make contact by 8 December 2019, the stepmother attempted to reach her repeatedly, but Tengi's phone was switched off. She eventually called the stepmother, probably about 6 weeks later, on 20 January 2020. During this brief emotional call, Tengi whispered and cried hysterically, stating, and I'm quoting from the statement, "The woman who offered me a job sold me to Nigerians." She further revealed that she was being held in a residential brothel in Johannesburg, where she and other girls, some as young as 12 years, were being exploited. She added, "They are sending us to different people," and she noted that her captors were armed. Tragically, Tengi's location, as well as the fate of the other potential child trafficking victims she mentioned, remains unknown. And my Lord, I'll just briefly pause here. I did make available the USAID study that I authored, and within that study there's about 3 diagrams that speaks to these invisible victims of trafficking, where there is consistent corroborative evidence that there are countless people in the building, in a room, where this comes out from victim testimony. I mean, when you enumerate these individuals, sometimes their names are known, or sometimes a mere reference when there was 5 or 6 others in the room. When you start enumerating these numbers, the statistics easily goes up to 10, easily 20 times 20. Again, just highlighting and underscoring how many of these cases are undocumented and how many that the untold number of victims that truly falls through the cracks. I'll continue reading. This really highlights that minimal attention has been given to the connection between certain cases of trafficking and reported cases of missing children in South Africa. These cases are intricate numbers presented in these data sets, while significant, reflect only a small fraction of the broader missing persons crisis in South Africa. Significant underreporting, limited investigative resources, systemic issues with law enforcement, corruption, complicity, and general indifference have all constrained accuracy and scope of these statistics. I'll just pause here, my lord,
Corruption in government and law enforcement has been widely reported and further entrenches the crime with reports of officials accepting bribes, issuing fraudulent documents, or even participating directly in trafficking operations. This complicity facilitates cross-border victim movement and shields syndicates from prosecution, eroding institutional integrity and public trust. The combination of systemic deficiencies and corruption sustains a low-risk, high-reward environment for traffickers, fueled by greed, porous borders, and fragmented enforcement. Trafficking in persons in South Africa, as articulated by those combating it, is a deeply entrenched and dynamic crime, necessitating a robust, unified response. The government's legal framework, though promising, is weakened by poor execution, resource deficits, and neglect of victim needs. Civil society NGOs offer essential support, yet their potential is limited by inadequate state backing. Systemic failures and corruption perpetuate an environment where traffickers thrive. Practitioners advocate for a comprehensive strategy. This includes bolstering of law enforcement training and funding, enhancing victim identification and support, and fostering government and NGO collaboration. They stress the need to combat corruption and address the enabling factors, including poverty, inequality, and lack of education, while adapting to new threats. Improved data collection and public awareness are also critical to dismantling the structures sustaining this crime. These insights compel the court to recognize the urgency of a coordinated, survivor-focused approach to eradicate trafficking in persons in South Africa. My Lord, if I may just ask, can I pause here? I just wanted to check that I should continue.
My Lord, I'm glad that the doctor has stopped there. I also wanted to ask whether we should perhaps just take a short body break. May I suggest, I know that we are on page 17, so we're almost to the end of the report. I don't know if my court thinks that this is perhaps
How
an
much
opportune-
time does the witness still have for us? Remember, he has another commitment later, and we still need to get cross-examination as well.
Yes.
Let's take 7 minutes past. I will pause the recording first. I'll keep the line live
Yes.
so that we don't lose it.
Yes.
Maybe we should take, if it suits the witness on that side, take a longer break for be 23 minutes until past. At the same time, you can use the opportunity to find out what happened to the absconder.
Well, my Lord.
And then we start at past and then try and run through until the end of the witness's
Yes.
evidence.
Yes.
Will that suit everyone else? I'm looking at the defense table. Till past, and don't tell me it's less minutes, Mr. Armson.
Court
We'll
pleases,
take the
my Lord.
adjournment till 11, and then we'll return. Thank you. Court will adjourn.
In the light of the brutality of the offence, a suspended sentence would not be justified. This would allow the offender to live his life in relative freedom, while the life of a vulnerable child who depended on those she trusted for protection is no longer free to live her life. Therefore, in the light of the seriousness of the offence, a custodial sentence is the only one which would justifiably be a suitable sanction. Though the offender and his co-accused has had numerous opportunities to take the court into their confidence, they have steadfastly refused to disclose the truth. On the other hand, the outrage of Joshlin's family, as well as the community, would satisfy the community's demands for justice if the court were to impose the maximum penalty for this most egregious violation of one of society's most vulnerable members. Thus, in the light of the information obtained, it is respectfully recommended for the court to impose the sentence of incarceration on Jacqueline Apollos.
And you confirm the contents of the report?
I do, my lord.
It's marked exhibit SS, double S. So we can move to the report of Mr. Van Ryn. Just to confirm, it seems to me it's 8 pages. And it's the one signed by yourself and Ms. Jordan.
Ms. Jordan, yes.
This one I'll indicate now really will be exhibit TT, double T. So once we've done the confirmation, it will be marked as such. So similarly, Mr. Peterson, please, if you can then go from paragraph 2.
Sure. The sources I have consulted is the offender, Mr. Stevino Van Ryn, the co-accused, Ms. Joshlin Smith, the file contents of the Department of Social Development, B67422 reference, the report of the late Mr. Lincoln Hartley, who was the former probation officer. This report dated the 6th of January 2017. Ms. Aisha Mostert, the sister of the offender, Ms. Hendrika Plakis, the maternal grandmother of the co-accused Jacqueline Apollos' daughters. His biological mother is deceased, as well as the biological father. They were Almarin and Andries van Ryn, respectively. He has an older sister, Board Bronwyn, but who has adopted the Islamic faith and is now known as Bahia. He has an older sister, Carly Philander. He has a younger sister, Aisha van Ryn. It's now Aisha Mostert. And a younger brother, J.C. van Ryn. His girlfriend, with whom he had cohabited before his incarceration, is Roche Strauss, and they have a daughter together, Hope Strauss, who is about 4 years old. The family and social background of the offender was investigated, and the following can be reported. The mother of the offender was born in Paarl, but was raised in Retreat, close to the southern suburbs of Cape Town. His eldest sister, Bronwyn, also known as Bahia, was born out of a fleeting relationship between her parents. Mr. Van Ryn's parents were married on the 12th of March 1988 after cohabiting for a short time. He is the middle child of 5 children. His father had not been home as he worked out at sea for months at a time, but on the occasion when he was home, he would imbibe excessive quantities of alcohol. His father's long absences from home, coupled with the father's subsequent drunkenness, unfortunately took a toll on the marital relationship, eventually leading to its dissolution. The father's drunken proclivity created domestic instability in the household, but reportedly this did not have a negative effect on the offender as reported by himself. A former probation officer stated in a 2017 pre-sentence report that the offender's mother had adequately managed the household after the dissolution of her marriage. Furthermore, though the strain and strife in the marital relationship were experienced by her as challenging, it nonetheless resulted in an increased closeness between her and her offspring. Mr. Van Ryn disclosed that his father had never assaulted him or his siblings or their mother during his bouts of drunkenness. However, his father had, during drunken rants, damaged furniture and household items, but this never bothered him. He had always been close to his father, despite his father's drinking, and was emotionally affected by his father's untimely death. He reported, however, that he had, over the years, overcome the emotional turmoil he experienced at his father's death, who was murdered by a close friend of his on the 29th of April 2010. His mother never remarried. She passed away in 2023. Mr. Van Ryn and his girlfriend, Roche Strauss, had cohabited for a period of about 5 years, not 4 years, as indicated in the report, my lord. One child was born out of the relationship, Hope Strauss, who is now almost 5 years old. housing and environment situation was that the residential area where the offender had resided, like most townships, suffers under the scourge of social evils, which includes unplanned pregnancies, social ineptitude, school dropouts, and drug and alcohol abuse, amongst other social pathologies. He, his girlfriend, and their daughter shared a two-bedroom house which provided them with sufficient privacy. In terms of his work history, the offender had for most of his life not been involved in the formal labour market. However, during periods of sobriety, he had attempted to put his life together by obtaining formal employment. On those occasions, he had been employed as a gardener, had been employed at Cape Town Fish Market in Langebaan for some time, and had reportedly also been a bartender. His education: Stevino van Rijn completed grade 6 at Deersville Primary School in Saldanha. Unfortunately, during his final primary school grade 7, he began associating with peers who influenced him negatively. During that time, he took to experimenting with mood-altering substances. That experimentation resulted in him losing motivation to complete his schooling. Religious affiliation: the family identifies as Christian. However, the tenets of the Christian faith had never been a decided factor in Stevino van Rijn's life. He had, however, been baptized as a child. His drug use: Mr. van Rijn disclosed his abuse of dagga, mandrax, colloquially known as buttons, and crystal methamphetamine. Physical and mental health: the offender is reported in good physical health. He had been stabbed with a knife on 3 separate occurrences, but this had not affected his health. He had performed adequately in primary school until he began using mood-altering substances. There is therefore no reason to suspect a cognitive deficit. Behavioral patterns: the offender took to experimenting with substances in early adolescence. This has resulted in him losing interest in school, subsequently leading to him terminating the schooling out of his own accord. This has left his mother alarmed and worried for his future, as she had always placed a high premium on educating her children. Though the offender had never been a gang member, he had since adolescence associated with persons who had a positive attitude towards crime and criminality. This unfortunate turn of events came about immediately after his father's death. His sister, Aisha Mostert, as well as the maternal grandmother of his co-accused children, Jacqueline and Apollos, described the offender as someone who is easily provoked. He is said to be high-strung, with no qualms to assault persons who angers him. Previous interventions: Stevino van Rijn had been afforded opportunities to turn his life around on several occasions, but he chose to continue on the negative trajectory his life had taken since early adolescence. My Lord, I must just pause here, because like the previous accused report I've read out, this information that I got from his SAP 69 is also not complete to the same base. The SAP 69 I have, however, showed that he was convicted of robbery in 2014, again of robbery in 2016, violating the Drug Traffic Offences Act in 2018, and for housebreaking in 2020. That's right.
The other arrests, he was not convicted in all of those charges.
It would seem to be the case, my Lord.
And that included a charge of murder in 2022.
Yeah, that is correct, my Lord.
Thank you.
He is, of course, like the previous accused's report I read out, has not been found guilty, and he is currently found guilty on a charge of kidnapping and human trafficking. In terms of my evaluation, the inquiry surrounding Stevino van Rijn's upbringing and personal circumstances revealed several risk factors emanating from his early teens. That is, associating with unsavory characters, the use of illicit substances, and potentially the death of his father, which left an indelible negative mark on his development. Thus, despite being raised in a home where positive moral values were inculcated from an early age, the offender nonetheless succumbed to factors external to the family. It should therefore be noted that early school living, substance abuse, and the negative community aspects had contributed to him behaving contrary to social norms and functioning outside of the law. However, Stevino van Rijn had been granted several opportunities to turn his life around, which he had flouted carelessly. He himself had acknowledged that his father's untimely death had impacted negatively upon him, but he is no longer a child and has the maturity to understand the errors of his ways. He has been described by both his sister and Mrs. Spikes as someone who is easily provoked, and in the light of his many infractions, he is clearly a menace to society. Moreover, the offender flatly denies any culpability in the matter. He acknowledges his substance abuse but continues to deny any involvement in Joshlin Smith's disappearance. In fact, he professed his innocence continually and blames the police for falsely accusing him, accuses the witnesses of lying, and the judge of being biased. The undersigned can therefore find no room for mercy or absolution. Leniency is further thwarted by his complete lack of remorse. In fact, upon questioning, he carelessly stated that he does not care what happened to Joshlin Smith. In terms of the sentencing alternatives, I have to repeat that a suspended sentence would therefore, in this matter, be completely inappropriate. The offender has throughout his life demonstrated a propensity towards crime and criminality. His propensity towards criminal activity, in addition to the egregious nature of this offence, would harm the faith of society in the criminal justice system if a suspended sentence were to be imposed. Therefore, a custodial sentence, in the opinion of the undersigned, would therefore be highly appropriate, given the age of the victim and her inherent vulnerability. Thus, in the light of the seriousness of the offence and the offender's apparent lack of remorse, the undersigned, in his considered opinion, finds that a custodial sentence would be the most appropriate sanction. Not only will it send a clear message that the courts will deal harshly with such matters, but that the life of an innocent child warrants the most severe penalty possible. The probation officer could find no redeeming qualities in the offender. He has a propensity toward criminal activities and is therefore a threat to society at large. Furthermore, as I already stated, the offender had not shown one iota of remorse.
And then you make the same recommendation
Yes.
as with Mr. Collins. You confirm the contents of the report?
I do, my
Mr.
lord.
Peterson?
Yes, I do.
Thank you. It's then marked Exhibit TT, double T. We now turn to the report in relation to Ms. Smith,
So I'll also start with this.
which we will mark ultimately as UU.
That's the good
And similarly, I take it the introduction is the same with your qualifications and so forth, and the employment. So we can start with paragraph 2 as well. Thank you.
Correct. The sources I have consulted is, of course, the offender, Ms. Raquel Smith. I also have consulted the report of a colleague of mine, Ms. Jarrell Benjamin, the report that she had compiled in 2018, dated 8 August. I'm also referencing Mr. Cass Van who was a psychologist at the Namakwa Treatment Center in Vredendal when she was sent there in 2018. The file contents of B618651 reference, her maternal aunt, Ms. Priscilla Collier, and Ms. Janae Moss, who is a social worker at the Siabonga Shelter for Abused Women in Vredenburg.
Can I just pause you there?
Sure.
So the file contents of that B6185 or 18651 We already heard about that contents
Yeah.
in the main trial by your colleague.
That is correct.
Good.
Her biological mother is Amanda. I neglected to put in the mother's married surname, which is Daniels. She has a biological father, but she was primarily raised by her grandmother, which is Rachel Smith. What I did not, just to pause here, my lord, I didn't put into the, no I did, I'll get to it later. She has a daughter, Joshlin Smith, a son, Requin Smith, and another daughter, Rochelle Smith. Ms. Raquel Smith's family social background. The offender, Ms. Raquel Smith, was reportedly born and raised until the age of about 12 in Springbok in the Northern Cape province, after which she relocated to Saldanha Bay. Reportedly, she suffered rejection by both her biological parents and was raised by her maternal grandparents. This was pointed out by her maternal aunt Priscilla Collier as a blatant lie. Raquel was in fact legally adopted by her maternal grandparents as an infant, but has had contact with her mother, biological father, and stepfather throughout her life. Ms. Raquel Smith later, when I read out the report to her, she said to me that it's not true, she's never had contact with her biological father. Then, to continue, her mother had 4, not 3, more children. According to Ms. Smith, this had left a negative impression on her as she struggled to process how her mother could, as she described it, turn her back on her, but not on her half-siblings. This statement given by Raquel Smith was, however, found to be a fabrication. Her mother was only 17 when she gave birth to her, who later married and has had 4 more children with her husband. Raquel Smith was never rejected by either her biological parents and was in fact supported emotionally and financially by her biological parents, maternal grandparents, and stepfather. Furthermore, Ms. Smith claimed to have been a victim of sexual abuse when she was 13 years old or thereabouts, which according to her had caused her great unhappiness and emotional upset throughout her life, a claim which was dismissed by her grandmother as well as her aunt Priscilla Collier. Raquel Smith had been romantically involved with Jose Imka, her daughter Rochelle's father. Reportedly, the relationship was characterized by domestic violence, which prompted her to seek relief at a shelter for abused women in Vredenburg. That relationship was terminated in 2021. The offender had later been romantically involved with a co-accused Jacqueline Apollos for about a year at the time of her daughter's disappearance. Housing and environment. Informal settlement where the offender had resided with the co-accused Jacqueline Apollos suffers under the scourge of social evils, which includes unplanned pregnancies, social inaptitude, school dropouts, and drug and alcohol abuse, amongst other social pathologies. They had been residing together for the best part of a year prior to their arrest and incarceration. The informal structure in which she had lived offered little in the way of privacy due to its highly restricted living space. In terms of work history, Raquel Smith had been employed at various locations as a cashier and also as a domestic worker on the West Coast. Her education, she completed grade 12 at Diazville Secondary School in Saldanha. In terms of her drug use, Ms. Smith first engaged in the smoking of dagga, which later escalated to crystal methamphetamine. Onset use started in adolescence over weekends for 15 years according to her application to Namakwa Treatment Center. She entered that treatment center on 30th of August 2018. She was discharged on the 11th of October 2018, but relapsed soon after being discharged. It appears that Ms. Smith has been struggling with drug-related problems such as the use of methamphetamine and cannabis for the past 20 years. Physical and mental health. The offender is reportedly in good physical health, except that she has a history of asthma and was relatively recently diagnosed with hypertension. Raquel Smith was regarded as suffering from mild depression in 2018 by a psychologist when she entered treatment for a substance dependency. During her treatment period there, she was also reported to have suicidal ideation, that is, thoughts about suicide, and recently complained about having trouble sleeping. Behavioral patterns. Raquel Smith presented with some behavioral challenges when she was on high school. Though she managed to complete a high school career successfully, her behavior took a turn for the worse when she began to use drugs regularly, resulting in threats of physical assault against her grandmother as well as her children, or child at the time. This turn of events prompted her grandmother to evict her from her house. In February of 2016 already, it was reported to the officers of the Department of Social Development of the offender's propensity to hold abusive language towards her eldest child and threats to harm him physically. At that time, the maternal great-grandmother of the child, that is, was the primary caregiver of the child, Requin Smith, not Joshlin Smith, Requin Smith. The great-grandmother and aunt had complained of Raquel's substance abuse and negative behavior. Priscilla Collet gave an account of Raquel's heavy-handedness in disciplining her children, whom she would not only frequently slap around their heads and body when angry, but threatened them with physical assault and verbal abuse in crude language. The women's shelter social worker Janae Moss, however, reported that Raquel had shown great care to Joshlin during their stay at the shelter, but this may only be because she had been surrounded by others, including carers and a social worker, and was not abusing substances during the time. But she had nonetheless and habitually abused her relatives, both verbally and emotionally, often swearing at her grandmother and Aunt Priscilla in crude and vile language. Her drug abuse over many years had alienated her from her family, including her grandmother who had raised her, and damaged her relationship with her biological mother. The offender attempted to bring the undersigned under the false impression that she had suffered rejection at the hand of both her biological parents. This, however, proved false, as she has had regular and meaningful contact with both biological parents, but as stated earlier, she now was not with her father, as well as her stepfather, who had in fact gone out of their way to assist her in finding employment and to set her on a steady path. Circumstances during the commission of the offence. Ms. Smith admits that she had been under the influence of crystal methamphetamine on the day of her daughter's disappearance. She further admitted to obtaining crystal meth for use by herself and the two co-accused. They were thus all three under the influence of crystal meth on the day in question. Ms. Smith, however, continues to deny any involvement in the disappearance of her daughter. She accuses the court of being biased, her legal representative of being incompetent, the witnesses of lying under oath, and the community of being misinformed. She merely speculated, when she was interviewed at least, that her daughter could be trafficked as a sex slave, but she believes her daughter to be alive. Previous interventions. Opportunities have been provided to the offender in the past, including referral to a rehabilitation centre for the treatment of her addiction, which she entered on the 31st of August 2018, and was provided with shelter at a centre for abused women in Vredenburg, not only in May of 2018, but again in August of 2019. In addition, the offender was included in a family strengthening program at the Department of Social Development in December of 2023. Her criminal record reflects that she has not been arrested before. Again, in terms of the victim impact statement, the undersigned has had no contact with the victim and can therefore not report her. My evaluation. At the time of engagement with Raquel Smith, during the interview with her on 21 May 2025 at Pollsmoor Correctional Centre, she appeared disengaged and demonstrated a lack of awareness regarding the gravity of the incident. She attempted to hoodwink the probation officer with falsehoods. In the first instance, she fabricated bold-faced lies about being rejected by her parents, and secondly claimed to have been sexually abused as a child. Also, consider that the mother of the co-offender, Margaret Abrams, as well as Raquel Smith's maternal aunt, Priscilla Collier, described her as manipulative. It is therefore not a stretch to conclude that Raquel Smith is the mastermind behind the trafficking of her own daughter. It is also quite disconcerting that Ms. Smith violated her daughter's trust in her, not only as her provider, but also as her protector. The drug abuse of the accused contributed to the inconsistency of the care and supervision of her children. Although she received substance abuse treatment, she has not internalized the program's objectives. Thus, her behavior throughout was that of an unreliable adult. Therefore, it is in the best interest of Ms. Smith's remaining children to be cared for in a family environment where parental responsibility is taken seriously as defined in the Children's Act definition of care, Act 38 of 2005. In terms of sentencing alternatives, therefore, a suspended sentence would not serve justice. The egregious nature of the offence and the community's outrage will not be satisfied with a suspended sentence. Such a sanction will only fuel the community's anger, which expects the court to deal decisively with the matter. A custodial sentence would therefore not only be appropriate, but just. The probation officer cannot find any redeeming qualities in Raquel Smith. Our primary concern during the interview with her was for herself, that is, attempting to convince the court to deviate from the minimum prescribed sentence. In addition, several aggravating factors apart from those already mentioned must be taken into account. Raquel Smith's coercion of others in carrying out the offence, abusing her child's vulnerability, using deception, abusing her power, and not least of which, receiving payment. My recommendation is therefore the same as the other two co-cases.
That is then marked Exhibit UU
As the court
and
pleases.
entered into the record.
As the court pleases, my
Any
lord.
questions from the state?
I don't have any further questions. Thank you.
Thank you, Mr. Harmsen. Before you start your cross-examination, may I just ask you the victim impact statements that were circulated? Are you going to have any issues with it? Yes, certainly. I just want to plan around the witnesses that's available around that.
Thank you, my lord. Yeah, no, there is no, we consent to that. No problem.
Ms. Inkabai?
Thank you, my lord. When the court is saying we're having any issues, what kind of issues are those, my lord?
Normally what happens with these victim impact statements, in this case it was prepared by the court preparation officer. So those are statements from other persons, and they normally just presented to the court. Now we know that some of these statements were handwritten, statements so that we can plan for tomorrow. It might only happen tomorrow morning. That's why I'm asking you, will there be objections to these statements as being read in? Because then we can give them overnight to Ms. Mokoena, who can then look at them. So when they read out in court, it makes it so much easier to translate them into English.
Yes, my lord. I didn't even have an opportunity to read them because they are written in Afrikaans, most of them.
Except for the language. Do you have any other issues with them, admissibility issues?
I'll have issues, my lord, because I don't know what is contained in those statements.
But you got them yesterday, didn't you?
Yes, I did, my lord.
And what plans?
Yesterday
did you,
late.
And what plans did you make to have an understanding of it?
I didn't have time to make any plans because yesterday I was traveling from Cape Town to Saldanha. This morning, the court started at 8:30. At
And
9:30.
tomorrow morning we're going to start. We didn't start at 8:30 this morning.
So I didn't have time
We
to
did
ask.
not start at 8:30 this morning
9:30, my lord.
because you said 8:30.
I corrected myself, my lord. 9:30. I didn't have time to ask the interpreter to assist me with the contents of those statements.
Of course, it's a mere favor that the court staff works after hours to assist defense counsel, and it shouldn't be abused. Let me just hear from Mr. Sivnarain.
Thank you, my
Mr.
lord.
Sivnarain, what are your take on these matters?
My Lord, there is a possibility that it may be handed in by consent. I just need to confirm the instruction, my Lord.
Can you, by this evening, just alert your colleagues what your stance is so that we can plan? Both you and Ms. Nkabai.
I'll do so,
Just
my
by
Lord.
this evening to alert them so that we can plan in the morning
As the court
as
pleases,
to
my
how
Lord.
to go about it. In the meantime, the ones that are in Afrikaans, I'm going to make them available to our interpreter for the court to make it easier tomorrow.
Thank you, my Lord.
So, Ms. Boltney, I know that you're here every day, but if you then want to be excused, instead of waiting, then you may. Good. I note the name from the covering report to the statements. Yes, thank you. Mr. Harmse.
Thank you, my Lord. My Lord, may I just establish I don't really see any need to cross-examine a probation officer. However, in this instance, I have some corrections I would like to be made.
Certainly.
And then I will just ask him regarding that.
Certainly.
Thank you, my Lord. Mr. Peterson, I represent Mr. Apollos. Just want to refer to your statement that you've read out now. First of all, to paragraph 11. Paragraph 11, and I'm going to, in conjunction with that, also paragraph 14, but let's start with paragraph 11. My client's instructions are that he did not say to you that, and I'm going to read the third sentence, except the heading. It starts with Mr. Pollast, then the third sentence starts on the right-hand side, as was usual, comma. Joshlin had gone out playing after returning from school. My client denies that he said that to you. That is not correct, I submit, and I will, in terms of the evidence, it is very clear that Joshlin didn't go to school that day. So my client says he didn't tell you that she, after returning from school.
Would you like me to respond?
Please, what do you say?
I cannot explain why he would now say that he didn't say that to me, because that's what he said to me on Sunday when I visited him in prison. And this report was also read out to him this morning, and he didn't object to that information this morning. So it's strange to me that he would object to it now.
Sorry, just tell me, when was this report read out to you this morning?
This morning, when they came from the correctional centre.
You read the report out to
Yes.
you?
You will recall, Mr. Harmse, at the outset this morning, when counsel came to see me in chambers, I had indicated to counsel, and I also referred to that on record later when Mr. Peterson wasn't here, that I became aware early morning that the social workers were on site. As we were doing planning with Colonel Moodley about the arrangements, they sought permission for the social workers to drive into the facility. That's how I knew that they were here early this morning. Because she had to give special arrangements to the people outside that they can come in with their vehicle into the facilities, because only certain people can park inside. So Mr. Peterson was here early this morning.
I remember your Lordship says that.
Yeah.
Thank you, my Lord. Then just before I carry on, just want to then refer to paragraph 12 as well. I take it that the court accepts that for sentencing purposes there's one conviction as per the SAP 69, which will most probably not, as your Lordship says, it doesn't make a difference.
It's of no moment. In any event, the one that's added on is a statutory offence, which doesn't even fall within one of the schedules.
Thank you, my Lord.
So I will disregard it for purposes of sentence in any event.
Thank you, my Lord. Let's go to paragraph 14, Mr.
Can I
Peterson.
just, going back to this point, at paragraph 11. So I became aware, and you were not here this morning when I spoke about the happenings on Saturday. So I became aware that I didn't know who the social worker was. Saw the names the first lot yesterday afternoon when I saw the reports. That you were going to go to the prison on Sunday in order to complete these reports. So when you consulted with Mr. Apollos, were you alone with him in an area?
Yes, we were in one of the wardens, I think one of the senior wardens' offices. So he was there, myself and my assistant, as well as one of the wardens.
Good. And were you aware at the time when he was telling you that Joshlin had returned from school that he was fibbing?
Yes.
You knew that?
Yeah.
Thank you, Lord.
Because it was common knowledge, especially if in the West Coast area, that those were the facts. She didn't go to school.
No.
And there were more than one version given to different people as to why she didn't go to school.
Lord, yes, and I won't waste court's time any further because that's the same issue I have with paragraph 14, the fourth paragraph from the top, also referring to the same incident, which we all know. It is common knowledge. It's right. Thank you. Thank you. I have no further.
Just to confirm, Mr. Peterson, that you were requested by my office to do these reports,
That is correct, my lord.
not by the state.
No, my lord.
Came from us. In fact, the letter that was sent came from our office.
That is correct, my lord.
Good. And that's also why it was fast-tracked, because we wanted to finish the case. And just to explain to you so that you were at ease, that incident of Saturday was also because it was impossible to avoid unnecessary expenditure which would have been fruitless because everything was planned.
Thank you, my Lord. I have no more questions then.
Thank you. Listen, Kabai. Mr. Peterson, we're going to try, and we might sit a bit later, but we're going to try and accommodate you so that you don't have to come back on another day.
It's perfectly right.
So it might get late, but just bear with us.
Why the court is suspecting that?
Miss Nkabai, do you really want me to come?
I'll prove the court wrong.
Are you going to surprise me?
Oh, gosh. Thank you, my Lord.
No,
Good
Miss Nkabai, I mean it seriously with Mr. Peterson. I have told Counsel in Chambers, and I've now referred to it twice or thrice in open court. Him and his colleagues were under tremendous pressure. It normally takes no less than 6 weeks to do a single report. That's a normal timeline. I gave them 3 weeks initially, and he had indicated, it wasn't because he was lazy, because they already started working from day one. But the message I got through my registrar was they want to do a proper job. They don't want to give me half-baked stuff. And I appreciated that, but I just couldn't allow the matter to be postponed. So from that time, Saturday afternoon, I was kept abreast of that things are moving. The correctional services informing our director of court operations. Yes, the social workers were at the prison. Yes, they are there. Things are moving. I had no contact. Our office had no contact with them further. So I know they've been working under tremendous pressure. And it's not often. Have you ever testified in the High Court before?
I have, my Lord.
Way back.
Last year.
And
this individual...
was it a pleasant experience?
It wasn't a pleasant experience.
Good. So I also know that they would most probably be under tremendous stress because they have to come here and we've been putting pressure. So I want to put him at ease, and I don't want to inconvenience him unnecessarily. Hence I'm saying to him, if we need to, we're already long over normal court hours. So it wasn't aimed at you, but I see you took the bait. Thank you.
Thank you, my Lord. Good day, Mr. Peterson.
Good afternoon.
Is this the first serious matter you were asked to prepare a pre-sentence report?
No, my Lord, it's not.
Do you always recommend maximum sentencing in all your serious matters?
No, I do not.
If I'm going to interrupt Ms. Nkabai again, I was surprised because normally the social workers go for the lesser sentences. I was very surprised to see that you have given the recommendation you gave, and you motivated one. I'm not saying you're right or wrong, but normally one expects, and the public normally say, but why do they want a probation officer's report is just to come off lightly. Because that's how that's the perception. And I expect that probation officers be objective when they give their reports.
Understandable, my lord.
Thank you. Yes, Mr. Kabai, sorry.
You spoke with my client, you spoke with his family members. Did you speak to any of the committee members?
No, I did not. Unless you regard these families as members of the community.
I'm referring to members of committee who are not family.
No, I have not.
Any reasons why you haven't?
I didn't even follow this on social media, on the TV, but it was difficult to not pick up snippets of information because people talk about it all over the place. The community is in uproar, and so you come across conversations all the time. But I deliberately tried to avoid that because I didn't want to have a bias when I did eventually. I anticipated that the court might ask for a probation officer's report, and I didn't want to approach it from a biased place. You understand what I'm saying?
No, I don't. Can you repeat?
I didn't want to have preconceived ideas about the three offenders. As I anticipated, as I've just said, I've anticipated the court might very well ask for a probation officer's report, and I didn't want to be influenced. I didn't follow it, but you pick up information here and you pick up a bit there. You watch TV, you go on you Google something and something comes up about Kelly Smith. So it wasn't possible to avoid it entirely. But that is my reason for not having spoken to specific members in the community.
Are you saying media has an influence
It could have an influence.
in your report?
No, it absolutely did not have an influence.
But you watched some information here and there about Joshlin's case.
What I merely pointed out was that it is impossible to avoid. You switch on the TV and there's something, you open a newspaper, there's something, you go to the shop to buy bread and you come across people talking about it. So it's not impossible to avoid it completely.
It cannot be impossible to avoid, but it can be impossible not to base your report or not to watch it in the view of basing your report on it. What is your comment on that?
Could you repeat, because I don't understand.
I'll make it clear so that you understand. You just said it was not possible for you to avoid what you see on TV. Is that correct?
Not entirely. It's not possible to entirely avoid what you see.
There are other parts you watched and you used them in preparation for your report.
No, my lord, not at all.
Okay, let me rephrase my question. When you say not entirely, what do you mean?
What I mean by that is, as I've stated twice already, that though I had not followed the entire saga, I made a point of not following it on social media or on TV, but it's impossible to avoid doing so completely. Because of social media, it's ubiquitous, it's everywhere. Sooner or later, you're going to see something on TV or see a cover on a magazine, or somebody has a picture in your WhatsApp, for example, as a status. So you can't avoid it, not completely. But to suggest or imply that I was in any way biased towards either of the three offenders would be wrong.
We're not yet there. Let's go back to your answer. When you say you did not completely, can you tell this court those parts that you took from the media?
Nothing. I took nothing from the media. I wanted to base my report on the information that I could obtain from the offenders and from the other sources I've consulted.
Completely, entirely. I'll leave that, Mr. Peterson. I'll come back to it later. Are you aware of any mitigating factors as far as my client is concerned?
Any what factors?
Mitigating
Mitigating
factors.
factors.
As I have stated in my report, it is difficult for me to find mitigating factors in your client.
Why it is so?
First and foremost, his first offence occurred when he was nearly 14 years old. Now I know that adolescents get up to mischief, but we have to look at the type of early offending behavior. And in this case, it was robbery, and it must have been serious enough for the court to sentence him. It's on his record. That says something. But quite apart from his immaturity inherent in the adolescent stage of development, he hadn't desisted from criminal behavior. He had continued. In fact, he has a bit of a reputation that you don't mess with him. He will beat you up, and he admitted it this morning when I said it to him. This is what I wrote in my report. He admitted to it. And he's been arrested on numerous occasions before. It is common that when we look at mitigating factors, to look at past behavior, and all his behavior so far, almost all his behavior so far, has pointed towards him having a positive attitude towards crime and criminality. If you look at recent past behavior, it is a good predictor of future behavior. I'm sorry, but Stevino van Rijn, even if he weren't found guilty on this offense, he would have offended again. I have no doubt about that.
You strongly ignored the fact that at the time of the commission of those alleged offenses, he was young. You ignored that completely.
I just admitted to it. I said I didn't ignore it. If you would recall, my lord, I had stated in my report that one is usually quite sympathetic towards adolescent offenders. But Mr. van Rijn is no longer an adolescent. He's a grown man. He knows what he's doing.
You ignored the fact that his last conviction was in 2020. To you, that is not a mitigating factor.
No. He was also using drugs, bear that in mind.
Using substance is not another mitigating factor?
No, it's not.
To you?
It's not a mitigating factor.
Can you point any evidence that suggests that my client is a danger to the community?
Yes, as I've just stated, my lord, the history of criminal offences, whether he has been found guilty or not, shows that he's positively inclined towards criminality. and in the light of what other people have said about his character and his abuse of substances, he is, in no uncertain terms, a menace to society.
Are you a judge or are you a social worker?
I am a social worker.
Okay, thank you.
But you're not only a social worker, Mr. Peterson. Don't undersell yourself. When I looked at your qualifications, you not only have a 4-year degree in social work, but you have a further degree in criminology.
That is correct, Mother.
So that would give you 7 years
Of education.
of tertiary education, at least.
Yeah, that's true.
So besides being a qualified and registered social worker with that 4-year degree, I've noticed that you have a further qualification in criminology. And it wasn't just a course, because you majored in it according to your CV. Can I just, I'm going to interrupt the cross-examination because it's a point that I wanted to come to, but I only got the document now. He was born in 1997.
Yes, Your Worship.
On the 15th of January.
Yeah.
So in 2014, how old would he have been?
17. He would have been 17. Not 14, 17.
17.
Yeah.
That's when the first 2 counts of robbery was committed.
Yeah. Forgive me, Your Honor.
Suspended sentence and correctional supervision. In other words, under supervision.
Yeah.
Now we know that the pre-sentence report was for the 2020 conviction. I'm jumping, I'm going to come back to the others.
Okay.
So that was October 2014. Let's accept he was 17 years old. 2 years later, and he would have been 19.
Yeah.
In fact, it was 2 days after his birthday. Robbery again. Then he got 2 years imprisonment. Of course, he didn't serve long because not long after that, a year later, that's when he got a fine for dealing in substances. Supposed to still be in prison. Then, 2 years after that, it says huisbrake plural. Again, 2 years imprisonment. But 6 months later, Correctional Services let him out on parole, which parole was going to run till (2022). And forget about the other early release on the previous one. So on the 2016 one, he still had that because he was released on parole on a previous occasion. Then he was readmitted to serve another 407 days. It's another year. And then we know that in that period, there were further arrests for which he was not convicted. So between that 2018 and 2020, there was a malicious injury to property for which he was arrested. Why he wasn't charged or convicted, we don't know. An assault, 2019, a housebreaking, 2019, a theft in 2019, a murder in 2022, and a possession of a dangerous weapon early in 2024. You said your take is he's a menace to society.
That is correct, my lord.
Yes, thank you, Mr. Kabak. It's obviously an inference that I can or may not draw, because not all of those information is in your report because you didn't have the SABC.
That is correct, yeah.
Do you agree, Mr. Peterson, that purpose of sentence includes rehabilitation?
I am, my lord.
Don't you think my client has self-rehabilitated himself
No,
in the last 5 years?
no.
Why do you say so?
Because he has just been found guilty of kidnapping and human trafficking. How does one make an argument for rehabilitation?
But also the last 5 years, we're now in 2025, the last I've checked. He was arrested in 2024.
Yes, that is correct.
But from 2020, he was in and out of prison and breaking his parole conditions. That's how I have it, this Kabai on the SAP 69s. Remember, he got the 2 years. They let him out quick. And then immediately, almost a few months later, got another 2 years. They let him out quick. And then, I don't know whether, let's accept the other 4 years should be 2 years, plus another 407 days that he was supposed to serve. So he couldn't have been out before late 2023, but he was charged with murder in 2022. He was charged with other things in 2024. It's nice to be rehabilitated like that.
And, my lord, he was given a parole, and he didn't break his parole terms and conditions. The young man has self-rehabilitated himself.
We're going to argue tomorrow. So if you want to raise that argument, then you've got to explain to me on page 3 or 4 on his SAP 69s, where there's an endorsement that he was readmitted on the 18th of October 2021 to serve the remaining portion of 407 days due to a violation of parole conditions. It's here, and he admitted it.
I'll address the court tomorrow, my lord.
Yeah, please, I'm looking forward to it.
You testify that my client suffers anger issues. Is that correct?
Can you repeat that question?
Suffers anger issues.
I didn't specifically use the word anger in his anger issues. I'm saying he's aggressive in nature. He's easily flies at the handle.
Will that not equally be said to as anger management, or is having anger issues?
I don't think this stems from anger. He was quite assertive when I engaged with him. He said, for example, he was honest when he said the death of his father had a negative effect on him. But he also said it doesn't bother him anymore. So where does the anger come from? There's nothing that anybody indicated that one could say as an anger issue. Not even he himself. He's just violent in nature, it seems.
That came from his own sister as well.
Correct, my lord.
What would you say if someone will be easily provoked? You cannot say that is anger if somebody is easily provoked?
Yes, my lord. When you are provoked, you become angry. That is human nature. But not all of us, when we are angry, decide to take the law into our own hands. That is maturity, decency.
On that note, Mr. Peterson, my client instructs me that he was never angry with you.
No, I can't say that he became angry with me.
You testify that my client told you that he's using substance. Do you think that prison will be a better place to address substance abuse?
Well, I do know that the prisons offer programs specifically geared towards substance abusers. So he will have access to assistance or help if he wants it.
How successful are those programs? Do you have any idea?
I cannot speak for programs specifically in prison. But I do know that most people who do enter treatment centers relapse, the majority of them. Because it's not just a treatment center for a couple of weeks or a couple of months. It's not a magic intervention. A lot depends on the type of support you need, how determined you are as an individual, and how you are willing to change your own conduct in order to facilitate your rehabilitations. To reinforce the point, I'm going to make the example of an alcoholic. Even though you have not taken anything for, let's say, 10 years, you are still an alcoholic in recovery. So it's difficult to say. It depends on you yourself.
Other than my client's previous convictions, what else have you based your recommendation on?
The fact that he had absolutely shown no remorse, none whatsoever. In fact, his response that he doesn't give a damn, or he doesn't care, sorry, I don't want to add, he doesn't care what happened to Joshlin.
Was that a slip, or were those the words that were used?
Those were his exact words.
Those were his words. He doesn't give a damn.
Not damn, sorry, I just said damn.
What did he say?
He said, I don't care what happened to Joshlin. In fact, the warden's response was, damn at his coat. You understand that expression?
No.
You are cold. The warden said he's cold. So, not only what he said, but how he said it. And then, of course, they are guilty. They've been found guilty. And yet, everybody insists on their innocence. So how does that reflect remorse?
So because he didn't show remorse, so he must be given a maximum sentence. This is the person who just told you that I'm innocent to this crime. How would you expect a person who's saying I'm innocent to be remorseful at the same time? How do you expect that? Please explain to me, I want to understand.
Somebody can admit or claim to be innocent and be as guilty as sin. I don't believe that he has shown remorse because he admits his innocence, and even when it was pointed out, but how could a competent court find you guilty? There must have been a reason. They still insist.
Who asked that question? How can a competent court?
I reminded him, I said to him, a
Oh,
competent
that
court
competent
found you guilty. So what you were saying, in fact, then he responded and he said, everybody else is wrong. The community is making up stories. The police have beaten a confession out of them. Everybody else is wrong, just not them. They're innocent.
That phrase, competent court, came from you?
From me, yes.
Okay. So because of what you've counted, automatically is guilty.
The court has found him guilty. Who am I to say that he's not?
Okay. Just this question. About the programs and you mentioned previous convictions, you mentioned remorse. That's where you based your recommendation. What else?
As I've stated before, the long list of previous arrests and convictions, the early onset of criminal activity, the substance abuse, the continued denial of guilt, and just the frequency and the type of offences that he has been arrested and convicted, the variety of offences that he has been arrested for and found guilty of. The fact that there is such a variety also says that somebody is positively attitude towards crime and criminality. And in the light of that, not just that alone, but consider that Jacquin's children's grandmother of his two children, as well as his own sister, spoke of his propensity towards violence. All of these factors together says, as I said before, Stevino van Rijn is a menace to society.
He told you he lost his father.
Yes.
At his early age. Don't you think that might have contributed?
It might have, in all honesty, it might have contributed, especially because he says he was close to his father. His sister Aisha had also said that they had been quite close, and when his father died, and I think it might also have to do with how his father died, he had lost interest in school, began to associate with the wrong type, and so it might have contributed, yeah. I will consider that.
Coming to his comments, especially the one where you said he told you that he doesn't care about Joshlin, my instructions are that my client could not have said that. He's a father of a 4-year-old daughter himself. He could not have said he doesn't care about Joshlin. Those are my instructions. What is your comment?
He's lying.
Who's lying, him or you?
He is lying.
Okay, all right. Why would he lie?
To save his own skin, my lord.
Come again?
Maybe to solicit sympathy.
Oh, okay.
So you are being told, Mr. Peterson, you made it up.
Yes, that is what the
That's
defense
what's been suggested.
Yeah.
Mr. Peterson, I'm not saying you made this up.
So
You might not have
I'm
had-
not done, Ms. Nkabai.
Oh, sorry, my lord.
So I'm going to follow it up with the same question you were asked. Why would you make that up?
I have no reason to make anything up, my lord.
Now I'm just asking you the same questions, just from the other side.
Get it?
Thank you, Ms. Nkabai.
I didn't say you made this up.
Not saying you,
There
Ms.
might be
Nkabai. Your
many-
client says he made it up because your client says he never told him that. This morning when you read the report back to him, did he say anything about it?
Nothing, my lord. Nothing.
My client instructs me that you didn't hear him correctly. He was saying he is caring about Joshlin.
He's what?
Caring about Joshlin.
Not true.
I have 3 convictions for my client. 2 of robbery and housebreaking. You mentioned the 4th one. Can you remind me about the 4th one?
As I said, this was in the census page. 2 of robbery, 1 of violating the Drug Trafficking Act, and 1 of housebreaking. That's the convictions I have. I don't know if your document reflects.
I'll tell you what I have on the signed SAP 69 and admitted by the accused in this court. 13th of October 2014, 2 counts of robbery. 17th of January 2016, another robbery. 28th of March 2018, dealing in drugs. And then housebreakings, there are 2, but not sure whether it could have been a duplication on the SAP 69s. It doesn't look like it, but those were housebreakings. So it actually, your indication on page 6 of your report is in line with the SAP 69s, except you might have given less than what he has, of what he admitted in my presence in this court. And he signed the SAP 69s on the day of the conviction, in case anybody doubts it. Yes, thank you, Mr. Kabba.
From these 4 previous convictions, there's none of human trafficking and kidnapping. Would you agree with me?
I agree, my lord.
Softly. I have no questions for this witness, my lord.
Thank you, Mr. Sidney. Anybody want to take a break? Mr. Signaran, are you going to be long?
No, my lord. I'm not sure how many instructions my client has, but I'm not going to be long.
Maybe just check, because if you're going to be long, then we might take a 5-minute or so break, just to stretch.
May I approach, my lord?
I'm not going to rush you, so you can just indicate to me. If you're going to say I'm going to be 10 minutes, then we push through, because I notice it's already past 4, and I'm okay. I'm comfortable.
May I approach him, my lord?
Yeah. Thank you. I've just been told by my registrar they were prepared to be at least 8 o'clock, so we still have a lot of time to go.
Okay.
Thank you, my lord. My lord, I request that we take a 5-minute adjournment. That would allow me an opportunity to take the instructions.
Let me say it's 8 minutes past 4. Is it okay if we take it till 4:30? I suspect, when the reports are read by Ms. Smith would have seen it, but now when it was read to her this morning, or whenever that was read, and Mr. Peterson consulted last week in Polsmoor with her, according to the report. Now that it's read in open court, she might remember things, and let's rather clear that. It's not that long. It's now 10 past, so it's a 20-minute break. During that period, we will then do all the admin for the warrants and so forth. Get that out of the way. And you will have sufficient opportunity to consult.
Thank you, my lord.
Good. Till 4:30, then we'll come.
It says that she was reportedly born and raised until about the age of 12 in Springbok. Who or what was your source of information?
She herself shared that information, my lord.
This was during an interview recently?
Yes, last week.
And further on, you go down to say that that was a blatant lie. What did you mean by that?
That she had been rejected. That is a lie. as reported by her maternal aunt, Priscilla Collier.
Did you confirm whether she was adopted as an infant?
No.
My instructions from accused number 3 are that she never told you that she lived with her parents until the age of 12.
Does that paragraph say that she lived with her parents until the age of 12?
No, my lord. The way I understood it, my lord, it was that she was born and raised until the
In
age
the
of
Northern
12.
Cape. But does that mean, if you look at the first sentence, it says that she was reportedly born and raised until the age of about 12 in Springbok in the Northern Cape, and then relocated to Saldanha. But if you look at the last sentence in that paragraph, it says she was in fact legally adopted by her maternal grandparents as an infant. So it could be, and it's not clear from that paragraph, that the grandparents were in fact in the Northern Cape and then moved down here when she was about 12. It could mean either or, because I recall when her sister testified on the merits trial, she confirmed that, and the social worker that testified, that she was adopted by her grandparents as an infant. That came out in the main trial. Also, insofar, seeing that we're on that paragraph, remember Mr. Peterson says that she told him that she suffered rejection by her biological parents. But again, her sister's evidence was that was in fact not so, because she spent some times there in the Northern Cape on holiday, or when they came down here, and that's when the sisterly bond also developed between the two. Either when she was up in the Northern Cape, or their family came down from the Northern Cape here. Maybe just to clarify that, but that's how I have it. When I read it last night, I tried to figure out this move, and because it made sense then that she had good memories of the Springbok area, a la Mr. Coetzee. Remember that discussion between them when they met at the funeral, and he specifically mentioned Springbok area, but the evidence was also her parents, her mother and her stepfather and siblings were living in Aggeneys. So then it made sense to me. There was a time where she was younger and remember the area because of that discussion. So I was just trying to figure out, reading in on the other evidence.
My Lord, I was also seeking clarification because it was not that clear to me as well. But
Yeah.
the court has assisted me. Thank you, my Lord. Now, sir, you say that you believe that it was a blatant lie when she said that she was rejected by her parents.
Correct.
Why do you say that?
Because she clearly was not. She had spent school holidays by her parents in the Northern Cape. And also she has had contact, according to her aunt, she has had contact with her biological father as well.
Which she denied this morning.
This morning she denied that, yeah.
What else in your report that you read out did she have an issue with this morning?
She pointed out that she had 4 more siblings, half siblings, not 3, as I've stated on page 3, which is just the next paragraph after the one you mentioned. Let me just see if there's anything else. On page 5, she pointed out that I mistakenly spoke of Joshlin Smith when it should actually have been her son, Requin Smith.
Anything else?
No, I don't think there's anything else. Oh, of course, she denied the statement that she made about being sexually abused when she was in her late childhood, early teens. She said she never said that, and it was pointed out to her, but you did, and your aunt said that you have made the story up. She said, oh, okay, well, if that is what they say.
Can I just also, my understanding of the 3 and the 4 was that I recalled, and I didn't check it, just from my memory, that when her sister testified, she spoke about 5. And then she said, but she had a brother who passed away young. I recall when she testified about that.
Thank you, Miller. Now, so you'd agree with me that you only went through your report with Ms. Smith just around 9 o'clock this morning?
Correct.
And that you did not have sufficient time to get a proper explanation from her with regard to what she disputed or was unhappy about?
No, I think we had sufficient time. The entire report was read out to her, and I told her before I started reading the report to her, stop me if you are uncertain about anything or you want clarity, and that is what she had done. She stopped me when I said 3 children. She said, no, it's actually 4. She stopped me when she pointed out that I mistakenly spoke of Joshlin Smith when I should have spoken of Requin Smith, and she stopped me about the sexual abuse situation as well.
My instructions are that she was only able to tell you what she did not agree with you and could not give you a full and proper explanation and to show you why what information you received from some other source could be incorrect.
It is for that exact reason, my lord, that I asked Miss Smith to sign the report. She wrote here, report read out to me, and she signed it.
Yes, because you asked her to just sign the report, but those are my instructions. Is that your only comment?
I do not know what else the defense would like me to say.
My instructions are that the aspects in your report relating to her being abusive or threats of abuse to her grandmother and grandparents is not true. Do you have any comment on that?
Look, Miss Smith has been a long-standing client of the Department of Social Development. I did not only base those statements on what she had shared with me. That went to her aunt, and also there was information in the file.
The aunt seems to reside here in Saldanha.
Yes, she does, in Saldanha.
Because she could also comment on some of the other persons.
Correct.
Yes, she will deny that she ever had a relationship with her biological parents and that she was ever abusive to anyone. And that she took any other mind-altering substance or drugs besides crystal meth.
Is that a question or a statement?
Well, I'd just like your comment on the last portion of my statement, in that she did not make use or smoke daka or any other drugs.
That's what she said to me last week. I don't know why her story has not changed.
My Lord, may I just approach?
Certainly.
Thank you, my Lord. I've consulted. I have no further questions.
Thank you. Any questions, Ms. Swanepoel, as a result of the cross-examination?
No, thank you.
Mr. Peterson, do you have, in respect of all three persons, the reports that they've signed?
Yes, I do, my Lord.
Can you maybe just arrange with my registrar, because the reports we have were the ones that were sent through on email,
Yeah.
that we just make a copy, and we can do it here, of those pages so that I attach it to the exhibits. So before you leave, we can assist you with it upstairs. And again, thank you. And apologies for shunting you around.
It's understandable, my Lord. We understand that sometimes life throws the curveball, but it was an absolute pleasure.
Thank you so much, and pass my thanks also to the people in your office that assisted you. I know it was a team. A team effort.
It was. It was.
Thank you very much. So 8:30 tomorrow morning, will that be in order? Mr. Apollos, Mr. Van Rijn, Smith. We're going to start at 8:30 tomorrow morning. The planning is as follows. We're going to have the victim impact statements. Ms. Nkabai, is your witness local, or is there special arrangements to be made? Is the witness coming from Cape Town again tomorrow? Is the witness here now? But the witness was due to be at 11 o'clock. Any of the team driving in out from Cape Town in the morning? I just don't want to delay. How is the witness getting here, Ms. Dubai? Is there public transport? Maybe only taxis. Is there any of the persons coming from Cape Town for this case in the morning? I'm looking there at the media. Are you coming? Yes. Will you, and you're going to be early? Yes. There's a photographer in the media team. Would you be able to assist if needs be, to get the witness here? There you have it, Mr. Kabai. The gentleman with the long lens over there is willing to assist. Instead of the witness struggling with public transport to get here. And thank you so much. Thank you very much for offering. There we go. That's how a team works. 8:30 in the morning. And warrant officer, I'm sorry. You're going to get home long after dark. That's life. The court ledger.